So today we'll talk about another element of valid contract. We started with an offer and acceptance. So today we'll talk about intention to create legal relations. So for a contract to be enforceable, it is not enough that there has been a valid offer, that there has been an acceptance, or that consideration has been furnished under the contract. The parties to the contract must also have the intention to be bound by their agreements. So in discussing the intention to create legal relationship, we'll talk about three broad headings. We'll talk about agreements that are domestic in nature. We'll talk about commercial agreements, and we'll talk about intermediate situations or agreement. So when we talk about domestic agreement, the general principle or the general rule is that agreement between close relatives, such as spouses, such as siblings, parents, are generally leased with the intention not to be bound by such agreement. Remember, this is a general rule, and the general rule is based on a presumption that the parties do not agree to be bound by such an agreement. However, this presumption can be rebutted. By rebutting the presumption, we are trying to say parties can bring forth every evidence to show that even though it's a domestic agreement, the parties actually want to be bound by such agreement. For instance, where parties, the relationship, even though it's a domestic relationship, where the relationship has been estranged, that is, has gone sour, then there's a presumption that the presumption not to be bound has been rebutted. So in such a case, the courts may impute that, oh, the parties actually want to be bound by such an agreement. So generally, again, when parties are in a marriage relationship, like husband and wife, there is a rebuttable presumption that they are not to be bound by any contractual agreement they enter into. And I've referred you to some cases. You say Balfour and Balfour. I need you to compare Balfour and Balfour with merit and merit, and then you read Jones and Padavitin. You read Spellman and Spellman. So there are still some cases that we'll talk about in due time. So in commercial agreements, just like the opposite of domestic agreement, there is a presumption that the parties intend to be bound by their agreement. In such a case, you have agreement between probably colleagues at work or probably between uh, firms, between companies, or between people that are not even familiar with each other, they are not on domestic or social relationship. So the presumption is that the parties intend to be bound by their agreement. In doing this, you have to take note that where there's an express exclusion in the terms of the contract, that the contract is binding just in honor only, then that express exclusion shows that the parties are not to be bound by the agreement. So where there's express exclusion in the terms of the contract as to the pending nature of the contract, then the contract is not binding. Where the contract is a MEPOF, like you see our illustration that we used as to the advertisement of Dano milk, that maybe if you use close-up toothpaste, your teeth will become snow white. That is a MEPOF, just a statement to draw people's attention to patronize a particular product. That is not going to be taken to be a commercial agreement. It will not be bound. It will not be binding. And when there's a letter of intent to show that the parties are not to be bound by the agreement, then it will not be binding on the parties. Where there's a free gift, probably somebody gives you a free gift of which you have not furnished any consideration, there is a presumption that there is no intention to create a binding relationship, such that if something happens that questions the title of that free gift, then all the other party needs to show is that you have not furnished consideration, and that you cannot sue that person to enforce that contract. And then remember, the burden of proof that a certain agreement is not binding is on the party that is claiming that the agreement is not binding. Remember, in civil cases, the burden is on the preponderance of evidence, and he who asserts must prove. So I need you to see the case of Carlyle and Carbolik Smoke, then read Rose and Frank and Crompton Bros Limited. So there are situations where ordinarily, on the face of it, the agreement appears to be a domestic agreement. And you know that, oh, there's a presumption that this is not binding agreement. But certain conditions must have happened that makes the contract to be binding, or that makes the agreement to be binding on the parties. In such a situation, we say there is an intermediate situation where the presumption that a domestic agreement is not binding has been rebutted, such that the agreement now becomes binding. Or in a situation where a commercial agreement that is presumed to be binding is rebutted, and that agreement becomes binding. So when you have a situation where the presumptions as to those two cases have been rebutted, then you say this is an intermediate situation, and such an agreement becomes binding or not binding, depending on the nature of the agreement. So an example of this is collective agreement. Let me give you an example of what collective agreement is. Probably you have a kind of agreement between ASU and the federal government. ASU is a collective, it's like a representative of teaching staff in Nigerian universities. So that agreement is a collective agreement on behalf of all the teaching members or teaching staff of Nigerian universities. So the kind of agreement they have with the federal government is ordinarily seen as a commercial agreement, right? So if there is a situation that the government is putting forward to say, no, even though we signed this, it is only binding in honor alone, but we will do it at our pace, and that leads to all the strike and everything. Then if it can be shown that, oh, even though this agreement was signed by both parties, the government is not bound to follow the agreement, then you will say this is an intermediate situation. Please take note, I am not saying the government is not bound by the agreement signed with ASO. I'm just using that as an example of collective agreement. So I need you to see the case of Apperson and Littlewood and the case of Packer and Clark. So this is by far the shortest topic we'll be treating in law of contract. So what I would have loved us to do if we were to be in a face-to-face class is to discuss these cases and for you to try to understand the nature of the agreement. That will be domestic, that will be commercial, and that will be intermediate. So what I've tried to do is to summarize the fact and the decision of some of the cases I mentioned. We talked about Balfour and Balfour, in which case the couple decided to go on vacation, and then the wife stayed back for treatment, and the husband promised that he will be paying her £30 monthly. When he failed to pay and the wife went to court, the court says no, there was no consideration and that she was not entitled to the payment. But when she appealed, the court still upheld and said because she had not provided consideration and they were spouses, and as such there's a presumption that they did not intend to be bound by such an agreement. So I need you to compare this with merit and merit, in which case the relationship has been estranged between the parties and the husband promised to continue to pay the wife £40 monthly in order to offset the mortgage. And when the wife sued and the husband tried to rely on the defense of domestic agreement, the court said no, because the parties were separated, there is an intention to be bound. So I need you to also read Apperson and Littlewood, read Packer and Clark. Packer and Clark is another clear example of intermediate agreement. Then there are some examples, there are some exercises. Probably when we meet online for our class, we'll discuss all the exercises. I have about 10. Then we'll talk about this when we are able to interact. So have a good day.